So my name is Emma Palmer. I'm an Associate Director and a collaboratively trained lawyer in the Family Department at Whitehead Monckton. And I'm here today with Sarah Brissenden. Over to you, Sarah.
Yes, I'm Sarah Brissenden. I'm a senior solicitor here at Whitehead Monckton, and I'm also a collaboratively trained lawyer.
Sarah and I want to talk today a little bit about the new divorce law, but perhaps more importantly, how that impacts upon negotiations around finances and children and other issues stemming from a separation. Sarah, you were going to start off, weren't you, by talking a little bit about the new divorce law?
Yeah. On the 6th of April this year, the divorce laws finally changed, and it is an exciting time as we hope that the changes can really benefit clients. Prior to the law changing, unless couples had been separated for 2 years or more, they would need to blame the other for the breakdown of the marriage. This has now changed, and couples no longer need to assign any blame to the other, and they can even apply to the court on a joint basis. Like I say, I think this will really benefit clients, as so often the first conversation is about divorce and then resolving the finances which arise from their divorce. We try our best to encourage couples to try and resolve matters as amicably as possible. And when starting off that process, assigning blame can really be starting off on the wrong foot. We do want to talk to you about the different ways in which we can resolve finances more amicably, and Emma is going to start off the different processes with a bit of detail about collaborative law.
Absolutely, Sarah, thank you. Yeah, I mean, it's really fair to say that as a divorce lawyer who's been practicing for over 20 years and somebody who has wanted the law to change for such a long time, it's so exciting for us to have this change. And it really is an opportunity, we hope, for clients to come in and talk to us from the very start on a very amicable footing without having to assign blame. So there are lots of opportunities and lots of options, should I say, to resolve issues relating to the children and issues relating to finances. One of my biggest passions is the collaborative law approach. And Sarah and I are both, as we said earlier, trained collaborative lawyers. Collaborative came in from the States a while back. I call it the touchy-feely tree-hugging version of family law. And the idea behind it is that everything is done in meetings and all issues are discussed in meetings, all financial disclosure takes place in meetings. So there shouldn't be any shocks. There shouldn't be an email coming into your inbox with information or questions or details that you're not expecting. It gives clients control over the process. And the idea is that you appoint your collaboratively trained lawyer and your separated spouse or partner appoints their collaboratively trained lawyer. And those lawyers then have an initial discussion to set a meeting date and an agenda, and then everybody attends that first meeting. Now, the agenda is usually drafted by the lawyers, but it's very much something that the clients themselves can input in. So, for example, the lawyers may be focused on how we're going to deal with the divorce process and financial disclosure. But for the clients, what might be important is arrangements for the children. And so that first meeting, we can tailor the agenda to what the clients want and need. The whole aim of the collaborative process is to avoid court. And so one of the documents that we look at in the collaborative law process is something called the participation agreement. And ideally that is signed at the first meeting, and it sets out the terms that the collaborative law process is going to be conducted upon. And fundamental to that is both parties agreeing that they will not go to court. And if you do decide for one reason that the collaborative process is not going to work for you or is broken down, and you do want to start a court process, then importantly, if the participation agreement has been signed, you cannot use that same lawyer to represent you in those court proceedings. And that really, in my mind, binds people to the process because hopefully you like your lawyer, you want to work with them, you don't want to start again, and that can get you over issues that perhaps otherwise might have caused the process to break down. We also, at the first meeting, encourage clients to prepare anchor statements, and those anchor statements are the important issues and aspects for them of why they want to enter into that process. Those statements can be prepared in writing or just done orally. And what is good about the statements is that further down the line, if we come to any difficulties in the discussions, then as collaboratively trained lawyers, we refer you back to those anchor statements in an attempt to try to get negotiations back on track. And that, again, can be a very effective technique. There are other options to the collaborative process, and in fact, where I practice in Canterbury, I do a lot of work using collaborative principles, but we call round table. So effectively it's the same process. You sit around a table, you negotiate, both clients will be there with their lawyers, but on the basis that you're not actually signing up to the participation agreement, because some clients don't feel for one reason or another that they want to. And in that case, then we would call that round table. So collaborative and round table, very much the same sort of principle. You get round a table, you roll your sleeves up and you try and deal with everything, but it's led by the clients. And I tend to find, I don't know about you, Sarah, that the clients who go through the collaborative law process with me come out of it thanking me and feeling as if the process has been something they had control over. It hasn't been dictated upon them.
Yeah.
Anyway, a bit of a whistle-stop tour of collaborative and round table, and Sarah's now going to take you through mediation.
Yeah, that's right. Mediation is another process which the whole aim is to, again, avoid court. Mediation can be a great way for couples to come to an agreement, and again, just like collaborative and round table, it's a face-to-face process. The couple come together in a room with one mediator. Of course, this process can be used when they need to make arrangements for their children as well. And again, this kind of process allows the couple to stay in control. They can arrange their meetings and are often in charge of what they discuss in the meetings. If mediation is being used to resolve the matrimonial finances, then the mediation can go ahead as and when the parties agree and exchange documents which they agree to, which they feel that they need to exchange. If the parties can come to a financial agreement within mediation, the mediator will then prepare a document called a Memorandum of Understanding, and it's within that document which records the agreement. The couple would then need to take that Memorandum of Understanding to a solicitor to draft up the consent order, and it's the consent order which you then send into the family court to be approved by a judge. Mediation can be very successful, and the mediator is really there to help facilitate a conversation between the couple. They don't give legal advice, but they do give legal information, and of course either party is free to go and see a solicitor if they feel that they need a bit of extra legal advice. Like I said, mediation is a face-to-face process, and some couples will of course find it difficult to get around a table, and there are processes which we can help, which you're going to discuss, Emma.
Yeah, absolutely. And I think it's really important to say that for some clients, it will not be appropriate to be around a table or face-to-face, particularly if you've got issues of controlling coercive or domestic abuse.